My name is Chuck Penzine. I'm an attorney here in the office of Penzine and McBride. We are an estate, business planning, and probate firm located in the state of Michigan. We are doing a series on the various aspects of estate planning and the probate process, and today I wanted to talk a little bit about the difference between a trust and a will. Before I get into that, I wanted to offer a free 1/2 hour consultation, telephone consultation. By clicking on one of the links below, you can see my schedule. Schedule yourself for a free 1/2 hour consultation where we can discuss your estate planning needs, what's going on with your needs, what you need to have accomplished, and hopefully we can help you through that process. So as far as today's talk, we frequently get questions from clients by both on the telephone or when they come in for a meeting, trying to understand exactly the difference between what is a trust versus what is a will. A lot of people are familiar with the concept or term will, or last will and testament is another phrase or another label, but they don't really understand the difference between the will and a trust. So I wanted to clear up a little bit of that confusion today and hopefully provide some understanding of what one accomplishes versus what the other one accomplishes. First of all, when we talk about either will or trust, we're talking about how are our assets disposed of after we've passed? Who gets what? Whether charities get money or somebody gets a car, somebody gets a house, somebody gets $1,000, or somebody gets 50% of the estate. All of those are questions that are addressed either in a will or in a trust. One of the main differences between a will and a trust is how they're effectuated or enforced. In a will, the request is made to the probate court to enforce the terms of the will. Now, the will generally name somebody as the personal representative, and it will also name the recipients of gifts under that will. The probate court is the venue that enforces those terms and makes sure they take place. Now, in the case of a will, there's a formal proceeding called opening a probate. I'm sure most of you have heard about what that is. When you open a probate, you file a case in the probate court. The probate court then takes jurisdiction over that will and makes sure that things happen according to what the directives contained in that will might have been. Now, the parties who are interested in the estate, whether they be children, creditors, they're going to receive a gift out of the estate, anything like that. Those parties are interested. They have a right to notices under the estate. They have a right to understand exactly what the totality of the estate might be. They can then object or file objections regarding any aspect of the proceeding as it takes place, from the introduction of the will all the way through the accountings, what's being distributed and how that's being distributed. All of that happens in the probate court in whatever county where the person might have passed or was residing at the time they passed. So that's a very formalized, very public process. There are documents that are filed which detail the value of the estate, the assets that were owned at the time of the decedent's passing, and who is going to get what. All of those things are documented and filed within the probate file. It's a very public process. Anybody who would like to know can go into that court file, look up those documents, and understand exactly what was going on. Now, the trust is different in that although it disposes of our assets, it transfers our assets to some third parties, or whether it be our children, charities, or whomever. It is a private process. It's a legal contract or an agreement between the person who makes the trust and eventually the successor trustee, whomever that might be, who would be the person to effectuate those directions. It's a private affair in that there isn't a formal probate filing that's made. There isn't necessarily any documents that are filed other than deeds or things of that nature that might effectuate some direction that was taken under the trust. And it essentially avoids the entire probate process if it's done correctly. So the trust has some advantages. It also has great flexibility in terms of how we pass on those assets, how we restrict certain assets going to certain people, things of that nature. But that's fairly complicated. We'll get into that in a later video. But the important thing to remember, the difference between a will and the difference between that and a trust is whether or not the assets go through probate. And a lot of people want to have a trust to avoid probate. Now, there's some things we can do to avoid probate with certain kinds of assets, but the trust is generally one way to avoid that probate process. So it has some advantages for certain people if they're trying to accomplish certain things. So the best way to figure out if a trust or a will is appropriate for your circumstances is to sit down with an estate planning attorney. And again, as I talked about earlier, we would offer to have a 10-minute, or not a 10-minute, a 30-minute telephone conference with you, free of charge, through our office. There are some links in the description of this video that provide you with the ability to make those arrangements to schedule some time. We can sit down, we can talk about what's going on in your situation and try to figure out which way you want to go in terms of resolving your estate plan. So if you would like to do that, please let us know. Otherwise, I want to thank you for taking the time to watch this video, and thank you for coming to my page. If you would like to have or hear more about the estate planning process and the various things that can take place and things that we can help you with, I would invite you to subscribe and like the video, and then you'll receive notifications of future videos, future content. So again, thank you for visiting and appreciate it. We'll see you next time.